Chapter 13, Legal and Regulatory Environment. Learning Objectives. After studying this chapter, you should know about Regulatory Framework of Indian Financial Markets. Some of the important regulations in the Indian securities market. Code of conduct prescribed for research analysts. Management of conflicts and disclosure requirement for research analysts. Surveillance mechanism of exchanges ASM and GSM. Regulatory infrastructure in financial markets. The regulators in the Indian financial market ensure that the market participants behave in a responsible manner so that securities market continues to be a major source of finance for corporate and government, and the interest of investors is protected. Objective of all regulators is to create a fair and competitive marketplace with intermediaries ensuring high standard of services to the market participants. Briefs about various regulators who regulate and contribute towards development of the financial market are as given below. Ministry of Finance. The Ministry of Finance is an important ministry within the Government of India. It handles issues related to taxation, financial legislation, financial institutions, capital markets, state finances, and the union budget. It comprises of 5 departments. Department of Economic Affairs is the nodal agency of the central government to formulate and monitor India's macroeconomic policies, covering monetary and fiscal policy as well as the functioning of the capital market including stock exchanges. Other responsibilities include the mobilization of external resources and managing all policy matters relating to the design, form, shape, size, security features, operational issues, printing/production, etc. of the banknotes and coins. A principal responsibility of this department is preparation of the union budget annually. Department of Expenditure oversees the expenditure management of Government of India. It is concerned with, among other things, the administration of various financial rules and regulations including service conditions of all central government employees. The department is also involved with matters such as financial assistance to states and borrowings by states. Department of Revenue. This department handles the matters relating to all the direct and indirect taxes through 2 statutory boards, namely the Central Board of Direct Taxes, CBDT, and the Central Board of Excise and Customs, CBC. Department of Financial Services. This department covers banks, insurance, financial services provided by various government agencies and private corporations, pension reforms and industrial finance and micro, small and medium enterprise. Department of Disinvestments. This department is responsible for systematic policy approach to disinvestment and privatization of public sector undertakings. The department is also concerned with the financial policy relating to the utilization of proceeds of disinvestment. Ministry of Corporate Affairs. The Ministry of Corporate Affairs is primarily concerned with the administration of the Companies Act and other allied acts, rules, and regulations framed thereunder, mainly for regulating the functioning of the corporate sector in accordance with law. The issuance of securities by companies is also subject to the provisions of the Companies Act. The Registrar of Companies, ROC, is the authority appointed under the Companies Act to register companies and to ensure that they comply with the provisions of the law. The ministry is also responsible for administering the Competition Act 2002, which has replaced the Monopolies and Restrictive Trade Practices Act, 1969, MRTP. The ministry also supervises 3 professional bodies, viz. the Institute of Chartered Accountants of India, ICAI, the Institute of Company Secretaries of India, ICSI, and the Institute of Cost and Works Accountants of India, ICWAI. The Ministry of Corporate Affairs is also vested with the responsibility of administering the Partnership Act, 1932, the Companies Donations to National Funds Act, 1951, and the Societies Registration Act, 1980. Reserve Bank of India. Reserve Bank of India, RBI, is the central bank of the country which has the responsibility of administering the monetary policy. Its key concern is to ensure the adequate growth of money supply in the economy so that economic growth and financial transactions are facilitated, but not so rapidly which may precipitate inflationary trends. This is borne out in its preamble, in which the basic functions of the bank are thus defined. To regulate the issue of banknotes and keeping of reserves with a view to securing monetary stability in India and generally to operate the currency and credit system of the country to its advantage. In addition to the primary responsibility of administering India's monetary policy, RBI has other important responsibilities such as financial supervision. The main functions of RBI are listed as below. 1. As the monetary authority. To formulate, implement, and monitor the monetary policy in a manner as to maintain price stability while ensuring an adequate flow of credit to productive sectors of the economy. 2. As the regulator and supervisor of the financial system. To prescribe broad parameters of banking operations within which the Indian banking and financial system functions. The objective here is to maintain public confidence in the system, protect the interests of the people who have deposited money with the banking system, and facilitate cost-effective banking services to the public. 3. As the manager of foreign exchange. To administer the Foreign Exchange Management Act 1999 in a manner as to facilitate external trade and payment and promote orderly development and maintenance of the foreign exchange market in India. 4. As the issuer of currency, to issue currency and coins and to exchange or destroy the same when not fit for circulation. The objective that guides RBI here is to ensure the circulation of an adequate quantity of currency notes and coins. 5. Developmental role, to perform a wide range of promotional functions to support national objectives. 6. Banking functions. RBI acts as a banker to the government and manages issuances of central and state government securities. It also acts as banker to the banks by maintaining the banking accounts of all scheduled banks. Securities and Exchange Board of India. Securities and Exchange Board of India (SEBI) is the regulatory authority for the securities market in India. SEBI was established under Section 3 of SEBI Act, 1992 under an Act of Parliament. The preamble of the SEBI Act describes the basic functions of SEBI thus: to protect the interests of investors in securities and to promote the development of and to regulate the securities market and for matters connected therewith or incidental thereto. Thus, SEBI's primary role is to protect the interest of the investors in securities and to promote the development of and to regulate the securities market by measures it thinks fit. SEBI's regulatory jurisdiction extends over corporates in the issuance of capital and transfer of securities in addition to all intermediaries and persons associated with the securities market. It can conduct inquiries, audits, and inspections of all concerned and adjudicate offenses under the Act. It has powers to register and regulate all market intermediaries and also to penalize them in case of violations of the provisions of the Act, rules, and regulations made thereunder. SEBI has full autonomy and authority to regulate and develop an orderly securities market. The main functions of SEBI are listed as below. Protecting the interests of investors in securities. Promoting the development of the securities market. Regulating the business in stock exchanges and any other securities markets. Registering and regulating the working of stockbrokers, sub-brokers, etc. Promoting and regulating self-regulatory organizations in securities market. Promote investors' education and training of intermediaries in the securities market. Prohibit insider trading in securities. Prohibiting fraudulent and unfair trade practices. Regulate substantial acquisition of shares and takeover of companies. Calling for information from, undertaking inspection, conducting inquiries and audits of the stock exchanges, intermediaries, self-regulatory organizations, mutual funds, and other persons associated with the securities market. SEBI merged with the Forward Markets Commission on September 28, 2015 and now regulates the commodities markets in India. It is the regulatory body that oversees regulating and promoting forward and futures trading in commodities. The regulator's role includes monitoring the trading conditions in the forward markets, including demand and supply and prices, and take necessary action to streamline the functioning of the market. It advises the government on granting and withdrawing recognition to associations and undertakes inspection of the associations. It prescribes regulatory measures for limits on open positions of clients and members, circuit filters to control price volatility, managing risk through margins and specifying regulations for physical delivery of contracts and penalty for defaults. Insurance Regulatory and Development Authority of India, IRDAI. IRDAI regulates the insurance sector in India in accordance with the terms of the IRDAI Act, 1999. IRDAI is the licensing authority for insurance companies and defines the capital and net worth requirements for insurance companies. IRDAI's mission is to regulate, promote, and ensure orderly growth of the insurance sector, including the reinsurance business, while ensuring protection of the interest of insurance policyholders. It ensures the adherence of insurance products to the rules laid down and defines the rules for the terms and conditions of insurance contracts such as sum assured, surrender value, settlement of claims, nomination and assignment, insurable interest and others. It regulates the distribution of insurance products by laying down the qualification and training requirements of intermediaries and the payment of commission to distributors. IRDAI supervises the functioning of the Tariff Advisory Committee that determines the rates for general insurance products. It also lays down the modalities for investment of funds by insurance companies. Pension Fund Regulatory and Development Authority, PFRDA. The PFRDA is the authority entrusted to act as a regulator of the pension sector in India under the PFRDA Act 2013. It was constituted in October 2003 with the following responsibilities: A. To promote old age income security by establishing, developing, and regulating pension funds. B. To protect the interests of subscribers to schemes of pension funds and related matters. The PFRDA has been assigned the responsibility of designing the structure of funds and constituents in the National Pension System, NPS. It is responsible for registering the various constituents such as the fund managers, custodians, central record-keeping agency, and trustee banks, and to define the parameters of their roles and responsibilities. The PFRDA shall A. Deal with all matters relating to the promotion and orderly growth of the pension market. B. Propose appropriate legislation for the purpose indicated above. C. Carry out such other functions as may be delegated to the authority. Insolvency and Bankruptcy Board of India, IBBI. IBBI, established under the Insolvency and Bankruptcy Code 2016, is the regulator for overseeing insolvency process as well as the insolvency professionals. It has regulatory oversight over insolvency professionals, insolvency professional entities, and insolvency professional agencies. It is responsible for making and enforcing rules related to corporate insolvency resolution, corporate liquidation, and individual insolvency resolution and individual bankruptcy code. It is also appointed as the authority for regulation and development of valuers in India. Important regulations in Indian securities market. The Indian securities markets are governed by several acts, regulations, and bylaws. Some of the relevant ones are described below. Securities Contracts Regulation Act, 1956. The Securities Contracts Regulation Act, 1956, SCRA, provides for direct and indirect control of virtually all aspects of securities market to SEBI, instruments, intermediaries, issuers, and investors. It prevents undesirable transactions in securities by regulating the business of securities dealing and trading. The Act covers a variety of issues, of which some are listed below. 1. Granting recognition to stock exchanges. 2. Corporatization and demutualization of stock exchanges. 3. The power of the central government to call for periodical returns from stock exchanges. 4. The power of SEBI to make or amend bylaws of recognized stock exchanges. 5. The power of the central government exercisable by SEBI also to supersede the governing body of a recognized stock exchange. 6. The power to suspend business of recognized stock exchanges. 7. The power to prohibit undesirable speculation. Securities and Exchange Board of India Act, 1992. The SEBI Act of 1992 was enacted to provide for the establishment of a board to protect the interests of investors in securities and to promote the development of, and to regulate the securities market and for matters connected therewith or incidental thereto. The SEBI in the broader sense performs the functions as stated in the above paragraph. However, without any prejudice to the generality, the Act also provides for the following measures. Section 11(1) of the SEBI Act, 1992 lays down that subject to the provisions of the SEBI Act, 1992, it shall be the duty of the board to protect the interests of investors in securities and to promote the development of and to regulate the securities market by such measures as it thinks fit. Further, Section 11(2) lays down that the measures that SEBI could adopt that may include the following. A. To regulate the business in stock exchanges and any other securities markets. B. To register and regulate the working of stockbrokers, subbrokers, share transfer agents, bankers to an issue, trustees of trust deeds, registrars to an issue, merchant bankers, underwriters, portfolio managers, investment advisors, and others associated with the securities market. SEBI's powers also extend to registering and regulating the working of depositories and depository participants, custodians of securities, foreign institutional investors, credit rating agencies, and others as may be specified by SEBI. C. To register and regulate the working of venture capital funds and collective investment schemes, including mutual funds. D. To promote and regulate SROs. E. To prohibit fraudulent and unfair trade practices relating to the securities market. F. To promote investors' education and training of intermediaries in the securities market. G. To prohibit insider trading in securities. H. To regulate substantial acquisition of shares and takeover of companies. I. To require disclosure of information, to undertake inspection, to conduct inquiries and audits of stock exchanges, mutual funds, other persons associated with the securities market, intermediaries, and SROs in the securities market. J. To perform such functions and to exercise such powers under the Securities Contracts Regulation Act 1956 as may be delegated to it by the central government. K. To levy fees or other charges pursuant to the implementation of this section. L. To conduct research for the above purposes. Further, SEBI is also empowered to enforce disclosure of information or to furnish information to agencies as may be deemed necessary. SEBI Act 1992 empowers SEBI to impose penalties and initiate adjudication proceedings against intermediaries and market participants on various grounds. Securities and Exchange Board of India Prohibition of Insider Trading, Regulations 2015. The regulations prohibiting insider trading have been made pursuant to Section 30 of the SEBI Act 1992. The regulations define insider as any person who is a connected person or one in possession of or having access to unpublished price-sensitive information. A connected person is defined by the Act as any person who is or has during the 6 months prior to the concerned act been associated with a company directly or indirectly, in any capacity including by reason of frequent communication with its officers or by being in any contractual, fiduciary or employment relationship or by being a director, officer or an employee of the company or holds any position including a professional or business relationship between himself and the company whether temporary or permanent that allows such person directly or indirectly access to unpublished price-sensitive information or is reasonably expected to allow such access. Further, an explanation is provided of the expression person is deemed to be a connected person in detail. Such persons are deemed to be connected persons until the contrary is established. Examples of such a person are A. An immediate relative of a connected person or B. A holding company, subsidiary, or associate company. Or C. An intermediary as specified in Section 12 of the SEBI Act 1992 or an employee or director thereof, or D. An investment company, trustee company, asset management company, or an employee or director thereof, or E. An official of a stock exchange or of a clearing house or a corporation, or F. A member of board of trustees of a mutual fund or a member of board of directors of the asset management company of a mutual fund or is an employee thereof, or G. A member of the board of directors or an employee of a public financial institution as defined in Section 272 of the Companies Act 2013, or H. An official or an employee of a self-regulatory organization recognized or authorized by the board, or I. A banker of the company, or J. A concern, firm, trust, Hindu undivided family, company, or association of persons wherein a director of a company or his immediate relative or banker of the company has more than 10% of the holding or interest. The Regulation 2N defines unpublished price-sensitive information as any information relating to a company or its securities, directly or indirectly, that is not generally available which upon becoming generally available is likely to materially affect the price of the securities and shall, ordinarily including but not restricted to, information relating to the following. 1. Financial results. 2. Dividends. 3. Change in capital structure. 4. Mergers, demergers, acquisitions, delisting, disposals, and expansion of business and such other transactions. 5. Changes in key managerial personnel. Regulation 3(1) of the SEBI Prohibition of Insider Trading, Regulations 2015 states that an insider shall not communicate, provide, or allow access to any unpublished price-sensitive information. relating to a company or securities listed or proposed to be listed to any person including other insiders except where such communication is in furtherance of legitimate purposes, the performance of duties or discharge of legal obligations. This provision is intended to cast an obligation on all insiders who are essentially persons in possession of unpublished price-sensitive information to handle such information with care and to deal with the information with them when transacting their business, strictly on a need-to-know basis. It is also intended to ensure that organizations develop practices based on need-to-know principles for treatment of confidential information in their possession. As per Regulation 4, no insider shall trade in securities that are listed or proposed to be listed on a stock exchange when in possession of unpublished price-sensitive information. When a person who has traded in securities has been in possession of unpublished price-sensitive information, his trades would be presumed to have been motivated by the knowledge and awareness of such information in his possession. However, the insider may prove his innocence by demonstrating the circumstances as mentioned in the regulation. Connected persons have to establish that any trades done by them were not in violation of the regulations. Trading by insiders has to be disclosed in the prescribed form. Disclosures include those relating to trading by such person's immediate relatives and by any other person for whom such person takes trading decisions. Pertaining to the initial disclosures, every person on appointment as key managerial personnel or a director of the company or upon becoming a promoter or member of the promoter group shall disclose his holding of securities of the company as on the date of appointment or becoming a promoter, to the company within 7 days of such appointment or becoming a promoter. The continuous disclosures have to be made in such form and such manner as may be specified by the board from time to time. As per the SEBI's regulations, an organization needs to appoint a compliance officer who is responsible for setting forth policies and procedures and monitoring adherence to the Code of Fair Disclosure and Code of Conduct aimed at preservation of price-sensitive information. The principles of fair disclosure include ensuring prompt, uniform, and universal dissemination of UPSI to avoid selective disclosure, ensuring information provided to analysts and consultants is not UPSI, and developing best practices to record the proceedings in meetings with analysts and investor relation conferences to ensure official confirmation of the information provided. Designated persons who have access to information as part of their functions cannot trade in the securities during the period in which they are expected to hold UPSI. The compliance officer will decide when trading can commence based on factors such as when the UPSI will become generally available information. Designated persons include analysts, law firms, auditors, and consultants, among others. Trading by the designated persons is subject to pre-clearance by the compliance officer if the value exceeds the limits set by the board of directors. Entities handling UPSI, such as auditors, analysts, consultants, and others, are also required to formulate a code of conduct to monitor the trading in securities by their employees. Chinese wall. To prevent the misuse of confidential information, the organization/firm shall adopt a Chinese wall policy which separates those areas of the organization/firm which routinely have access to confidential information considered insider areas from those areas which deal with sale/marketing/investment advice or other departments providing support services considered public areas and processes which would permit any designated persons to cross the wall. The employees in the insider area shall not communicate any price-sensitive information to anyone in the public area. The employees in the inside area may also be physically segregated from the employees in the public area. The demarcation of the various departments as inside area may be implemented by the organization/firm. However, in exceptional situations, employees from the public areas may be brought across the wall and given confidential information on the basis of need-to-know criteria. Such cases should necessarily be intimated to the compliance officer. These regulations also state that analysts, if any, employed with the organization/firm while preparing research reports of client company or companies shall disclose their shareholdings/interest in such company or companies to the compliance officer, and the analysts who prepare research report of listed company shall not trade in securities of that company for 30 days from preparation of such report. SEBI Prohibition of Fraudulent and Unfair Trade Practices Relating to Securities Markets, Regulation 2003, amended in 2007, 2012, and 2013. The SEBI Prohibition of Fraudulent and Unfair Trade Practices Relating to Securities Market, regulations prohibit fraudulent, unfair, and manipulative trade practices in securities. These regulations have been made in exercise of the powers conferred by Section 30 of the SEBI Act, 1992. Regulation 2(1)(c) defines fraud as inclusive of any act, expression, omission, or concealment committed to induce another person or his agent to deal in securities. There may or may not be wrongful gain or avoidance of any loss. However, that is inconsequential in determining if fraud has been committed. Some of the instances cited are as follows. A willful misrepresentation of the truth or concealment of a material fact in order that another person may act to his detriment. B. A suggestion as to a fact which is not true by one who does not believe it to be true. C. An active concealment of a fact by a person having knowledge or belief of the fact. D. A promise made without any intention of performing it. E. A representation, whether true or false, made in a reckless and careless manner. Prohibition of certain dealing in securities. Chapter 2 of the regulations prohibits certain dealings in securities, covering buying, selling, or issuance of securities. Further, it specifies instances of fraud which include the following. A. Indulging in an act which creates a false or misleading appearance of trading in the securities market. B. Dealing in a security which is not intended to effect a transfer of beneficial ownership but to serve only as a device to inflate or depress or cause fluctuations in the price of such security for wrongful gain or avoidance of loss. C. Advancing or committing to advance any money to any person, thus inducing the other to buy any security in any issue only with the intention of securing the minimum subscription to such issue. D. Paying, offering, or agreeing to do either directly or indirectly to any person any money or money's worth for inducing such person for dealing in any security with the motive of inflating, depressing, maintaining, or causing fluctuation in the price of such security. E. Any act or omission which is tantamount to a manipulation of the price of a security. F. A person dealing in securities, publishing or causing to publish or reporting or causing to report any untrue information or information which he does not believe to be true prior to or in the course of dealing in securities. Prohibition of manipulative, fraudulent, and unfair trade practices. Dealing in securities shall be deemed to be a manipulative, fraudulent, or unfair trade practice if it involves any of the following. A. Knowingly indulging in an act which creates a false or misleading appearance of trading in the securities market. B. Dealing in security not intended to effect transfer of beneficial ownership but intended to operate only as a device to inflate, depress, or cause fluctuations in the price of such security for wrongful gain or avoidance of loss. C. Inducing any person to subscribe to an issue of the securities for fraudulently securing the minimum subscription to such issue of securities by advancing or agreeing to advance any money to any other person or through any other means. D. Inducing any person for dealing in any securities for artificially inflating, depressing, maintaining, or causing fluctuation in the price of securities through any means, including by paying, offering, or agreeing to pay or offer any money or money's worth, directly or indirectly, to any person. E. Any act or omission amounting to manipulation of the price of security, including influencing or manipulating the reference price or benchmark price of any securities. F. Knowingly publishing or causing to publish or reporting or causing to report by a person dealing in securities any information relating to securities, including financial results, financial statements, mergers and acquisitions, regulatory approvals which is not true or which he does not believe to be true prior to or in the course of dealing in securities. G. Entering into a transaction in securities without the intention of performing it or without the intention of change of ownership of such security. H. Selling, dealing, or pledging of stolen, counterfeit, or fraudulently issued securities, whether in the physical or dematerialized form. However, if 1. The person selling, dealing in, or pledging stolen, counterfeit, or fraudulently issued securities was a holder in due course, or 2. The stolen, counterfeit, or fraudulently issued securities were previously traded on the market through a bona fide transaction. 3. Such selling, dealing, or pledging of stolen, counterfeit, or fraudulently issued securities shall not be considered as a manipulative, fraudulent, or unfair trade practice. I. Disseminating information or advice through any media, whether physical or digital, which the disseminator knows to be false or misleading in a reckless or careless manner and which is designed to or likely to influence the decision of investors dealing in securities. J. A market participant entering into transactions on behalf of client without the knowledge of or instructions from client or misutilizing or diverting the funds or securities of the client held in a fiduciary capacity. K. Circular transactions in respect of security entered into between persons, including intermediaries, to artificially provide a false appearance of trading in such security or to inflate, depress, or cause fluctuations in the price of such security. L. Fraudulent inducement of any person by a market participant to deal in securities with the objective of enhancing his brokerage or commission or income. M. An intermediary predating or otherwise falsifying records, including contract notes, client instructions, the balance of securities statement, client account statements. N. Any order in securities placed by a person while directly or indirectly in possession of information that is not publicly available regarding a substantial impending transaction in those securities, its underlying securities, or its derivative. O. Knowingly planting false or misleading news which may induce sale or purchase of securities. P. Misselling of securities or services relating to the securities market. Misselling means sale of securities or services relating to securities market by any person, directly or indirectly by 1. Knowingly making a false or misleading statement, or 2. Knowingly concealing or omitting material facts, or 3. Knowingly concealing the associated risk, or 4. Not taking reasonable care to ensure the suitability of the securities or service to the buyer. Q. Illegal mobilization of funds by sponsoring or causing to be sponsored or carrying on or causing to be carried on any collective investment scheme by any person. For the purposes of this subregulation, for the removal of doubts, it is clarified that the acts or omissions listed in this subregulation are not exhaustive and that any act or omission is prohibited if it falls within the purview of Regulation 3. Notwithstanding that it is not included in this subregulation or is described as being committed only by a certain category of persons in this subregulation. Market participant shall include any person or entity registered under Section 12 of the Act and its employees and agents. Investigation. Chapter 3 of the SEBI Unfair Trade Practices Regulations 2003 relates to investigation of transactions of the nature described above. In particular, under Regulation 8(1), it shall be the duty of every person who is under investigation. A. To produce books, accounts, and documents that may be required by the investigating authority and also to furnish statements and information that is sought. B. To appear before the investigating authority personally when required to do so and to answer questions posed by the authority. SEBI may, without prejudice to the provisions contained in subsections 1, 2, 2A, and 3 of Section 11 and Section 11B of the SEBI Act, by an order in the interests of the investors and the securities market issue or take any of the following actions or directions either pending investigation or inquiry or on completion of the investigation or inquiry, namely: A. Suspend the trading of the security found to be or prima facie found to be involved in fraudulent and unfair trade practice on recognized stock exchange. B. Restrain persons from accessing the securities market and prohibit any person associated with securities market to buy, sell, or deal in securities. C. Suspend any office-bearer of any stock exchange or self-regulatory organization from holding such position. D. Impound and retain the proceeds or securities in respect of any transaction which is in violation or prima facie in violation of these regulations. E. Direct an intermediary or any person associated with the securities market in any manner not to dispose of or alienate an asset forming part of a fraudulent and unfair transaction. F. Prohibit the person concerned from disposing of any of the securities acquired in contravention of these regulations. SEBI may even take the following action against an intermediary. 1. Issue a warning or censure. 2. Suspend the registration of the intermediary. 3. Cancel the registration of the intermediary. Securities and Exchange Board of India Research Analyst Regulations 2014. Timely and accurate information about investment products is an important ingredient for making investment decisions. However, considering the volume and complexity of information, it would be difficult for an investor for analyzing and grasping the information. In this context, the research analysts play an important role. They study companies and industries, analyze raw data, and make forecasts or recommendations about whether to buy, hold, or sell securities. They analyze information to provide recommendations about investments in securities to their clients. Investors often view analysts as experts and important sources of information about the securities they review and often rely on their advice. However, such advice from investment analysts is many times prone to conflicts of interest that may prevent them from offering independent and unbiased opinions. Since the prime objective is to protect investors and enhance confidence in the market, it is a major concern of regulatory authorities to identify and deal with conflicts of interest arising from the production and dissemination of research reports. Indeed, the effort to address potential conflicts of interest affecting the production and dissemination of research by securities firms is truly a global one. With regulators in almost all developed market economies having proposed or implemented new rules for research-related conflicts of interest. Consensus globally is that a regulatory framework is required to ensure impartial reports, to address conflict of interest, to improve governance standards, to minimize market malpractices, etc. IOSCO report on addressing conflicts of interest in September 2003 has prescribed principles as under. Mechanisms should exist so that analysts' trading activities or financial interests do not prejudice their research and recommendations. Mechanisms should exist so that analysts' research and recommendations are not prejudiced by the trading activities or financial interests or business relationships of the firms that employ them. Reporting lines for analysts and their compensation arrangements should be structured to eliminate or severely limit actual and potential conflicts of interest. Firms that employ analysts should establish written internal procedures or controls to identify and eliminate, manage, or disclose actual and potential conflicts of interest on the part of analysts. The undue influence of issuers, institutional investors, and other outside parties upon analysts should be eliminated or managed. Disclosures of actual and potential conflicts of interest should be complete, timely, clear, concise, specific, and prominent. Analysts should be held to high integrity standards. Investor education should play an important role in managing analyst conflicts of interest. Accordingly, SEBI Research Analyst Regulation 2014 has come into existence. These regulations and their amendments set forth requirements to foster objectivity and transparency in security research and provide investors with more reliable and useful information to make investment decisions. Some of the important provisions of these regulations are defined here. Regulation 3 Application for Grant of Certificate. On and from the commencement of these regulations, no person shall act as a research analyst or research entity or hold itself out as a research analyst unless he has obtained a certificate of registration from the board under these regulations. Provided that any person acting as research analyst or research entity before the commencement of these regulations may continue to do so for a period of 6 months from such commencement, or if it has made an application for a certificate of registration under Subregulation 2 within the said period of 6 months till the disposal of such application. Provided further that an investment advisor, credit rating agency, asset management company, or fund manager who issues research report or circulates/distributes research report to public or its director or employee who makes public appearance shall not be required to seek registration under Regulation 3, subject to compliance of Chapter 3 of these regulations. Provided further that any principal officer, person associated with research services, and partner of a research analyst which is registered under these regulations shall not be required to seek registration under Regulation 3, subject to compliance with Regulation 7 of the Research Analyst Regulations. An application for grant of certificate of registration shall be made as specified in the first schedule to these regulations and shall be accompanied by a non-refundable application fee to be paid in the manner specified in second schedule to these regulations. Regulation 4, Issuance of research report by a person located outside India. Any person located outside India engaged in issuance of research report or research analysis in respect of securities listed or proposed to be listed on a stock exchange shall enter into an agreement with a research analyst or research entity registered under these regulations. Regulation 5. Furnishing of further information, clarification, and personal representation. 1. The board may require the applicant to furnish further information or clarification for the purpose of consideration of the application filed under Subregulation 2 of Regulation 3. 2. The applicant or his authorized representative, if so required, shall appear before the board for personal representation. Regulation 6. Consideration of application and eligibility criteria. For the purpose of the grant of certificate, the board shall take into account all matters which are relevant to the grant of certificate of registration and in particular the following, namely: 1. Whether the applicant is an individual or a body corporate or partnership firm or a limited liability partnership firm. 2. Whether in case the applicant is an individual, he and all persons associated with research services are appropriately qualified and certified as specified in Regulation 7. 3. Whether in case the applicant is a body corporate, the principal officer, individuals employed as research analyst, and all persons associated with research services are appropriately qualified and certified as specified in Regulation 7. 4. Whether in case the applicant is a partnership firm or a limited liability partnership, the principal officer, partners engaged in issuance of research report or research analysis, and all person associated with research services are appropriately qualified and certified as specified in Regulation 7. 5. Whether in case the applicant is a research entity, the individuals employed as research analyst and all persons associated with research services are qualified and certified as specified in Regulation 7. 6. Whether the applicant fulfills the deposit requirements as specified in Regulation 8. 7. Whether the applicant, individuals employed as research analysts, persons associated with research service and partners of the applicant, if any, are fit and proper persons based on the criteria as specified in Schedule 2 of the Securities and Exchange Board of India Intermediaries Regulations 2008. 8. Whether the applicant has the necessary infrastructure to effectively discharge the activities of research analyst. 9. Whether the applicant or any person directly or indirectly connected with the applicant has in the past been refused certificate by SEBI, and if so, the grounds for such refusal. 10. Whether any disciplinary action has been taken by SEBI or any other regulatory authority against the applicant or any person directly or indirectly connected to the applicant under the respective act, rules, or regulations made thereunder. 11. Whether the applicant is enlisted with a body or body corporate recognized under Regulation 14. Provided that the existing research analysts and research entities shall be deemed to be enlisted with such a body or body corporate from the date of recognition of such a body or body corporate. Provided further that the applicant whose application is received before the date of recognition of the body or body corporate as provided under Regulation 14 and who is granted the certificate after the date of recognition of such body or body corporate shall also be deemed to be enlisted with such a body or body corporate. Regulation 7. Qualification and certification requirement. 1. An individual research analyst or a principal officer of a non-individual research analyst registered under the Research Analyst Regulations, individuals employed as research analysts and partners of a research analyst, if any, engaged in research services shall have the following minimum qualifications at all times. 1. A professional qualification or graduate degree or postgraduate degree or postgraduate diploma in finance, accountancy, business management, commerce, economics, capital market, banking, insurance, actuarial science or other financial services from a university or institution recognized by the central government or any state government or a recognized foreign university or institution or association, or 2. A professional qualification by completing a postgraduate program in the securities market, research analysis, from NISM of a duration not less than 1 year, or a professional qualification by obtaining a CFA charter from the CFA Institute. 2. Persons associated with research services shall, at all times, have a minimum qualification of a graduate degree in any discipline from a university or institution recognized by the central government or any state government or a recognized foreign university or institution. 3. An individual registered as research analyst under these regulations, a principal officer of a non-individual research analyst, individuals employed as research analyst, person associated with research services, and in case of the research analyst being a partnership firm, the partners thereof, if any, who are engaged in providing research services shall have, at all times, a NISM certification as specified by the board from time to time. provided that a fresh relevant NISM certification as specified by the board from time to time shall be obtained before the expiry of the validity of the existing certification to ensure continuity in compliance with certification requirements. Regulation 8. Deposit. 1. A research analyst shall maintain a deposit of such sum as specified by the board from time to time. 2. The deposit shall be maintained with a scheduled bank, marked as lien in favor of a body or body corporate recognized by the board for the purpose of administration and supervision of research analysts in accordance with Regulation 14 of the Research Analyst Regulations, provided that such deposit shall be available for utilization in case the research analyst fails to pay dues emanating out of arbitration and conciliation proceedings, if any, under the online dispute resolution mechanism or such other mechanism as may be specified by the board. Regulation 9. Grant of Certificate of Registration. The board, on being satisfied that the applicant complies with the requirements specified in Regulation 6, shall send intimation to the applicant and on receipt of the payment of registration fees as specified in Second Schedule, grant Certificate of Registration in Form B to a research analyst or in Form C to a part-time research analyst, as the case may be under First Schedule, subject to such terms and conditions as the board may deem fit and appropriate, provided that an individual or partnership firm registered as an investment advisor may also be granted Certificate of Registration as a research analyst, subject to such terms and conditions as the board may deem fit and appropriate. As per Regulation 13, the certificate granted under this regulation shall, inter alia, be subject to conditions as specified by SEBI from time to time. Regulation 10. Period of validity of certificate. The certificate of registration granted under Regulation 9 shall be valid till it is suspended or cancelled by the board. Regulation 11. Renewal of certificate. The research analyst who has already been granted certificate of registration by the board prior to the commencement of the Securities and Exchange Board of India Research Analysts Amendment Regulations 2016 shall be deemed to have been granted a certificate of registration subject to payment of fee as prescribed in Schedule 2 of these regulations. Regulation 12. Procedure where registration is refused. 1. After considering an application made under Regulation 3, if the board is of the opinion that a certificate should not be granted to the applicant, it may reject the application after giving the applicant a reasonable opportunity of being heard. 2. The decision of the board to reject the application shall be communicated to the applicant within 30 days of such decision. 3. Where an application for a certificate is rejected by the board, the applicant shall forthwith cease to act as a research analyst, provided that nothing contained in this regulation shall affect the liability of the applicant under the law. Insolvency and Bankruptcy Code, IBC. The Insolvency and Bankruptcy Code 2016 is an act that consolidates all the laws related to reorganization and insolvency proceedings against companies, partnership firms, and individuals. The law stipulates time-bound resolution of insolvency proceedings. Under the law, any creditor to the firm, be it financial creditors or operational creditors, can bring in insolvency proceedings against a company if the undisputed amount outstanding is more than 1 lakh rupees. A financial creditor is one who receives consideration against the time value of money, in other words, earns interest on the amount outstanding. The corporate itself can initiate the proceedings if it defaults on any payment. Upon application for insolvency proceedings, the adjudicating authority, if it is satisfied that a default has occurred, appoints an interim resolution professional, IRP, who shall be responsible for managing the affairs of the company. Upon the appointment of IRP, the board shall be considered as dissolved and all management personnel are required to report to IRP. The IRP needs to collate all the lists of amounts outstanding and shall form the committee of creditors. Although operational creditors can initiate insolvency proceedings, they cannot be part of the committee of creditors. The committee of creditors is required to either confirm the appointment of IRP as the insolvency professional, IP, or it can appoint any other person as IP. IBC envisages that every insolvency proceeding should be completed within 180 days since the initiation of the process, and IP is responsible to carry it out. However, on many occasions, extension has been granted. The resolution can be in the form of restructuring of business, takeover, or it can result in liquidation. However, liquidation route is preferred only if no other option is available. Code of Conduct for Research Analysts. Code of Conduct as defined in the 3rd Schedule of Research Analyst Regulations. 1. Honesty and good faith. Research analyst or research entity shall act honestly and in good faith. 2. Diligence. Research analyst or research entity shall act with due skill, care, and diligence and shall ensure that the research report is prepared after thorough analysis. 3. Conflict of interest. Research analyst or research entity shall effectively address conflict of interest which may affect the impartiality of its research analysis and research report and shall make appropriate disclosures to address the same. 4. Insider trading or front-running. Research analyst or research entity or its employees shall not engage in insider trading or front-running of its own research report. 5. Confidentiality. Research analyst or research entity or its employees shall maintain confidentiality of report till the report is made public. 6. Professional standard. Research analyst or research entity or its employees engaged in research analysis shall observe high professional standard while preparing research report. 7. Compliance. Research analyst or research entity shall comply with all regulatory requirements applicable to the conduct of its business activities. 8. Responsibility of senior management. The senior management of research analyst or research entity shall bear primary responsibility for ensuring the maintenance of appropriate standards of conduct and adherence to proper procedures. Management of conflicts of interest and disclosure requirements for research analysts. Chapter 3 of SEBI Research Analyst regulations specify the requirements for the research analysts to deal with potential conflict of interests and define the disclosure requirements for research analysts. Regulation 15, establishing internal policies and procedures. 1. Research analyst or research entity shall have written internal policies and control procedures governing the dealing and trading by any research analyst for 1. Addressing actual or potential conflict of interest arising from such dealings or trading of securities of subject company. 2. Promoting objective and reliable research that reflects the unbiased view of research analyst, and 3. Preventing the use of research report or research analysis to manipulate the securities market. 2. Research analyst or research entity shall have in place appropriate mechanisms to ensure independence of its research activities from its other business activities. As per Regulation 15A, a research analyst is entitled to charge fees for providing research services from a client, including an accredited investor, in the manner as specified by the board. Regulation 16, limitations on trading by research analysts. 1. Personal trading activities of the individuals employed as research analyst by research entities shall be monitored, recorded, and wherever necessary shall be subject to a formal approval process. 2. Independent research analysts, part-time research analysts. Individuals employed as research analysts by research entity or their associates shall not deal or trade in securities that the research analyst recommends or follows within 30 days before and 5 days after the publication of a research report. 3. Independent research analysts, part-time research analysts. Individuals employed as research analysts by research entity or their associates shall not deal or trade directly or indirectly in securities that he reviews in a manner contrary to his given recommendation. 4. Independent research analysts, part-time research analysts. Individuals employed as research analysts by research entity or their associate shall not purchase or receive securities of the issuer before the issuer's initial public offering, if the issuer is principally engaged in the same types of business as companies that the research analyst follows or recommends. 5. Provisions of subregulations 2 to 4 shall apply mutatis mutandis to a research entity unless it has segregated its research activities from all other activities and maintained an arm's-length relationship between such activities. 6. Notwithstanding anything contained in subregulations 2 to 4, such restrictions to trade or deal in securities may not apply in case of significant news or event concerning the subject company or based upon an unanticipated significant change in the personal financial circumstances of the research analyst, subject to prior written approval as per the terms specified in the approved internal policies and procedures. Regulation 17, compensation of research analysts. 1. Research entities shall not pay any bonus, salary, or other form of compensation to any individual employed as research analyst that is determined or based on any specific merchant banking or investment banking or brokerage services transaction. 2. The compensation of all individuals employed as research analysts shall be reviewed, documented, and approved annually by Board of Directors/Committee appointed by Board of Directors of the research entity, which does not consist of representation from its merchant banking or investment banking or brokerage services divisions. 3. The Board of Directors/Committee appointed by the Board of Directors of the research entity approving or reviewing the compensation of individual employed as research analyst shall not take into account such individual's contribution to the research entity's investment banking or merchant banking or brokerage services business. 4. An individual employed as research analyst by a research entity shall not be subject to the supervision or control of any employee of the merchant banking or investment banking or brokerage services divisions of that research entity. Regulation 18. Limitations on publication of research report, public appearance and conduct of business, etc. 1. Research analyst or research entity shall not publish or distribute research report or research analysis or make public appearance regarding a subject company for which he has acted as a manager or co-manager at any time falling within a period of A. 40 days immediately following the day on which the securities are priced if the offering is an initial public offering, or B. 10 days immediately following the day on which the securities are priced if the offering is a further public offering. Provided that research analyst or research entity may publish or distribute research report or research analysis or make public appearance within such 40-day and 10-day periods, subject to prior written approval of legal or compliance personnel as specified in the internal policies and procedures. 2. A research entity that has agreed to participate or is participating as an underwriter of an issuer's initial public offering shall not publish or distribute a research report or make public appearance regarding that issuer before the expiry of 25 days from the date of the offering. Explanation: for the purposes of subregulations 1 and 2, the date of the offering refers to the first date on which the security was offered to the public. 3. Research analyst or research entity who has acted as a manager or co-manager of public offering of securities of a company shall not publish or distribute a research report or make a public appearance concerning the company within 15 days prior to the date of entering into and 15 days after the expiration/waiver/termination of a lockup agreement, or any other agreement that the research analyst or research entity has entered into with a subject company that restricts or prohibits the sale of securities held by the subject company after the completion of public offering of securities. Provided that research analyst or research entity may publish or distribute research report or research analysis or make public appearance regarding the company within such 15 days, subject to prior written approval of legal or compliance personnel as specified in the internal policies and procedures. 4. Research analyst or individuals employed as research analyst by research entity shall not participate in business activities designed to solicit investment banking or merchant banking or brokerage services business, such as sales pitches and deal roadshows. 5. Research analyst or individuals employed as research analyst by research entity shall not engage in any communication with a current or prospective client in the presence of personnel from investment banking or merchant banking or brokerage services divisions or company management about an investment banking services transaction. 6. Investment banking or merchant banking or brokerage services divisions personnel of research entity shall not direct the individuals employed as research analysts to engage in sales or marketing related to an investment banking or merchant banking or brokerage services and shall not direct the research analyst to engage in any communication with a current or prospective client about such division's transaction. Provided that subregulations 4 to 6 shall not prohibit research analyst or research entity from engaging in investor education activities including publication of pre-deal research and briefing the views of the research analyst on the transaction to the sales or marketing personnel. 7. Research analyst or research entity shall have adequate documentary basis supported by research for preparing a research report. 8. Research analyst or research entity shall not provide any promise or assurance of favorable review in its research report to a company or industry or sector or group of companies or business group as consideration to commence or influence a business relationship or for the receipt of compensation or other benefits. 9. Research analyst or research entity shall not issue a research report that is not consistent with the views of the individuals employed as research analyst regarding a subject company. 10. Research entity shall ensure that the individuals employed as research analyst are separate from other employees who are performing sales, trading, dealing, corporate finance advisory, or any other activity that may affect the independence of its research report, provided that the individual employed as research analyst by research entity can receive feedback from sales or trading personnel of brokerage division to ascertain the impact of research report. Regulation 19, Disclosures in research reports. A research analyst or research entity shall disclose all material information about itself, including its business activity, disciplinary history, the terms and conditions on which it offers research report, details of associates, and such other information as is necessary to take an investment decision, including the following. 1. Research analyst or research entity shall disclose the following in research report and in public appearance with regard to ownership and material conflicts of interest. A. Whether the research analyst or research entity or his associate or his relative has any financial interest in the subject company and the nature of such financial interest. B. Whether the research analyst or research entity or its associates or relatives have actual/beneficial ownership of 1% or more securities of the subject company at the end of the month immediately preceding the date of publication of the research report or date of the public appearance. C. Whether the research analyst or research entity or his associate or his relative has any other material conflict of interest at the time of publication of the research report or at the time of public appearance. 2. Research analyst or research entity shall disclose the following in research report with regard to receipt of compensation. A. Whether it or its associates have received any compensation from the subject company in the past 12 months. B. Whether it or its associates have managed or co-managed public offering of securities for the subject company in the past 12 months. C. Whether it or its associates have received any compensation for investment banking or merchant banking or brokerage services from the subject company in the past 12 months. D. Whether it or its associates have received any compensation for products or services other than investment banking or merchant banking or brokerage services from the subject company in the past 12 months. E. Whether it or its associates have received any compensation or other benefits from the subject company or third party in connection with the research report. 3. Research analyst or research entity shall disclose the following in public appearance with regard to receipt of compensation. A. Whether it or its associates have received any compensation from the subject company in the past 12 months. B. Whether the subject company is or was a client during 12 months preceding the date of distribution of the research report and the types of services provided. Provided that research analyst or research entity shall not be required to make a disclosure as per subclauses C, D, and E of Clause 2 or subclauses A and B of Clause 3. To the extent such disclosure would reveal material non-public information regarding specific potential future investment banking or merchant banking or brokerage services transactions of the subject company. 4. Whether the research analyst has served as an officer, director, or employee of the subject company. 5. Whether the research analyst or research entity has been engaged in market-making activity for the subject company. 6. Research analyst or research entity shall provide all other disclosures in research report and public appearance as specified by the board under any other regulations. 7. A research analyst or research entity shall disclose to the client the extent of use of artificial intelligence tools in providing research services. Regulation 19A, Website. A research analyst or research entity shall maintain a functional website containing such details as may be specified by SEBI. Regulation 20, Contents of Research Report. 1. Research analyst or research entity shall take steps to ensure that facts in its research reports are based on reliable information and shall define the terms used in making recommendations, and these terms shall be consistently used. 2. Research analyst or research entity that employs a rating system must clearly define the meaning of each such rating, including the time horizon and benchmarks on which a rating is based. 3. If a research report contains either a rating or price target for subject company's securities and the research analyst or research entity has assigned a rating or price target to the securities for at least 1 year, Such research report shall also provide the graph of daily closing price of such securities for the period assigned or for a 3-year period, whichever is shorter. 4. Research analyst or research entity shall ensure that the recommendations in the research report are corroborated by relevant data and analysis forming the basis for such research service. Regulation 21. Recommendations in public media. 1. Research analyst or research entity including its director or employee shall disclose the registration status and details of financial interest in the subject company if he makes public appearance. 2. If any person including a director or employee of an investment advisor or credit rating agency or asset management company or fund manager makes public appearance or makes a recommendation or offers an opinion concerning securities or public offers through public media, all the provisions of Regulations 16 and 17 shall apply mutatis mutandis to him, and he shall disclose his name, registration status, and details of financial interest in the subject company at the time of 1. Making such recommendation or offering such opinion in personal capacity. 2. Responding to queries from audiences or journalists in personal capacity. 3. Communicating the research report or substance of the research report through the public media. Regulation 22. Distribution of research reports. 1. A research report shall not be made available selectively to internal trading personnel or a particular client or class of clients in advance of other clients who are entitled to receive the research report. 2. Research analyst or research entity who distributes any third-party research report shall review the third-party research report for any untrue statement of material fact or any false or misleading information. 3. Research analyst or research entity who distributes any third-party research report shall disclose any material conflict of interest of such third-party research provider, or he shall provide a web address that directs a recipient to the relevant disclosures. 4. Provisions of subregulations 2 and 3 shall not apply to a research analyst or research entity if he has no direct or indirect business or contractual relationship with such third-party research provider. Regulation 23. Additional disclosures by proxy advisor. 1. All the provisions of Chapter 2, 3, 4, 5, and 6 shall apply mutatis mutandis to the proxy advisor, provided that the employees of proxy advisors engaged in providing proxy advisory services shall be required to have a minimum qualification of being a graduate in any discipline. Provided further that certification requirements for employees of proxy advisors engaged in providing proxy advisory services shall be as specified by the board. Provided further that time period for compliance with capital adequacy as provided in Subregulation 3 of Regulation 8 for proxy advisors shall be 3 years. 2. The proxy advisor shall additionally disclose the following. 1. The extent of research involved in a particular recommendation and the extent and/or effectiveness of its controls and procedures in ensuring the accuracy of issuer data. 2. Policies and procedures for interacting with issuers, informing issuers about the recommendation and review of recommendations. 3. Proxy advisor shall maintain the record of his voting recommendations and furnish the same to the board on request. 4. In case of any inconsistency or difficulty in respect of applicability of provisions of these regulations to proxy advisors, the board may issue such clarifications or exemptions as may be deemed appropriate. Regulation 24. General responsibility. 1. Research analyst or research entity shall maintain an arm's-length relationship between its research activity and other activities. 2. Research analyst or research entity shall abide by code of conduct as specified in the third schedule of the regulations and also mentioned in Section 13.3 of this chapter. 3. In case of change in control of the research analyst or research entity, prior approval from SEBI shall be taken. 4. Research analyst or research entity shall furnish to SEBI information and reports as may be specified by SEBI from time to time. 5. It shall be the responsibility of the research analyst or research entity to ensure that its employees or partners, as may be applicable, comply with the certification and qualification requirements under Regulation 7 at all times. 6. A research analyst or research entity shall disclose to the client the terms and conditions as may be specified by SEBI and take consent of the client on such terms and conditions in such manner as may be specified by SEBI. 7. A research analyst or research entity who uses artificial intelligence tools irrespective of the scale and scenario of adoption of such tools for servicing its clients shall be solely responsible for the security, confidentiality and integrity of the client data, use of any other information or data for research services based on output of artificial intelligence tools and compliance with any law for the time being in force. 8. Research analyst or research entity engaged in providing model portfolio shall abide by the guidelines issued by SEBI from time to time. 9. A research analyst shall ensure compliance with the investor charter specified by SEBI from time to time. Regulation 25. Maintenance of records. 1. Research analyst or research entity shall maintain the following records. 1. Research report duly signed and dated. 2. Research recommendation provided. 3. Rationale for arriving at research recommendation. 4. Record of public appearance. 5. Know your client records of the fee-paying client. 6. A register or record containing list of the clients along with client's PAN, the date and nature of the research service, details of the products/securities for which research service was provided and fee/consideration, if any, charged/received for such research service. 7. Records of communication including emails, call recordings, etc. with all clients including prospective clients in such manner as may be specified. 8. The terms and conditions of research services disclosed to the clients and the consent of the client thereon. 2. All records shall be maintained either in physical or electronic form and preserved for a minimum period of 5 years. Provided that where records are required to be duly signed and are maintained in electronic form, such records shall be digitally signed. 3. Research analyst or research entity shall conduct annual audit in respect of compliance with these regulations from a member of Institute of Chartered Accountants of India or Institute of Company Secretaries of India or Institute of Cost Accountants of India and submit the report of the same in such manner as may be specified by SEBI. Regulation 26. Appointment of Compliance Officer. 5. A non-individual research analyst or research entity shall appoint either 1. A compliance officer or 2. An independent professional who is a member of Institute of Chartered Accountants of India or Institute of Company Secretaries of India or Institute of Cost Accountants of India or member of any other professional body as may be specified by SEBI, provided that such a professional holds a relevant certification from NISM as specified by SEBI, who shall be responsible for monitoring the compliance of the provisions of the Act. These regulations and circulars issued by SEBI. 6. Where independent professional referred in subregulation 1 of this regulation is appointed for monitoring compliance, the principal officer shall submit an undertaking to SEBI or the body or body corporate recognized under Regulation 14 of these regulations to the effect that principal officer shall be responsible for monitoring the compliance in respect of the requirements of the Act, regulations, notifications, guidelines, instructions issued by SEBI. Regulation 26A. Dispute resolution. All claims, differences, or disputes between a research analyst or research entity and its client arising out of or in relation to the activities of the research analyst or research entity in the securities market shall be submitted to a dispute resolution mechanism that includes mediation and/or conciliation and/or arbitration in accordance with the procedure specified by SEBI. Regulation 26B. Redressal of investor grievances. 1. The research analyst shall redress investor grievances promptly but not later than 21 calendar days from the date of receipt of the grievance and in such manner as may be specified by the board. 2. SEBI may also recognize a body corporate for handling and monitoring the process of grievance redressal within such time and in such manner as may be specified. Regulation 26C. Client-level segregation of research services and distribution activities. 1. An individual research analyst shall not provide distribution services. 2. The family of an individual research analyst shall not provide distribution services to the client to whom research services are being rendered by the individual research analyst. And no individual research analyst shall render research services to a client who is receiving distribution services from other family members. 3. A non-individual research analyst or research entity shall have client-level segregation at group level for research services and distribution services. Explanation. 1. The same client cannot be offered both research and distribution services within the group of the non-individual entity. 2. A client can either be receiving research services where no distributor consideration is received at the group level or distribution services where no research services fee is collected from the client at the group level. 3. Group for this purpose shall mean an entity which is a holding, subsidiary, associate, subsidiary of a holding company to which it is also a subsidiary, an investing company or the venturer of the company as per the provisions of Companies Act, 2013 for non-individual research analyst or research entity which is a company under the said act, and in any other case, an entity which has a controlling interest or is subject to the controlling interest of a non-individual research analyst. 4. Non-individual research analyst or research entity shall maintain an arm's-length relationship between its activities as research analyst and distributor by providing research services through a separately identifiable department or division. 5. Compliance and monitoring process for client segregation at group or family level shall be in accordance with the guidelines specified by SEBI. Regulation 32, Chapter 5 Liability for action in case of default. Research analyst or research entity who 1. Contravenes any of the provisions of the Act or any regulations or circulars issued thereunder. 2. Fails to furnish any information relating to its activity as a research analyst as required by the Board. 3. Furnishes to the Board information which is false or misleading in any material particular. 4. Does not submit periodic returns or reports as required by the Board. 5. Does not cooperate in any inquiry, inspection, or investigation conducted by the Board. 6. Fails to resolve the complaints or fails to give a satisfactory reply to the Board in this behalf shall be dealt with in the manner provided under the Act or the Securities and Exchange Board of India Intermediaries Regulations. 2008. Exchange Surveillance Mechanisms GSM and ASM. Stock exchanges facilitate transparent trading in securities between buyers and sellers. By enabling such trades, the market also enables discovery of fair price of the securities. However, in certain cases, it is possible that some traders may employ unscrupulous trade practices that distort the prices and adversely affect the interest of other traders. In order to enhance the integrity of the market and to protect investor interest, SEBI, along with the exchanges, implements several surveillance mechanisms. They monitor stocks based on objective set of criteria and impose certain restrictions or additional rules in relation to their trading in order to prevent unscrupulous practices. Graded Surveillance Measures GSM. GSM is targeted on securities with low market capitalization or net worth where the valuation is not commensurate with the business fundamentals. Once the companies are shortlisted based on such criteria, they are listed to alert and advise investors to be extra cautious while dealing in such securities, as well as to advise market participants to carry out extra due diligence on such securities. These securities shall be monitored by the exchanges and SEBI, and they may place various restrictions such as follows. A. Placing securities under trade for trade category, that is, only delivery-based trading. B. Requirement for surveillance deposit. C. Reducing the price band. D. Increasing the margin requirement. E. Freezing of price on the upside. Further, members of the exchange and trades in such stocks are also closely monitored. The criteria for putting a security under GSM are as follows. Companies with net worth less than or equal to 10 rupees crores and net fixed assets less than or equal to 25 rupees crores but trading at a negative PE or at a PE multiple that is 2 times the PE of the benchmark index. This criteria is not applicable to securities already under suspension and certain other securities, including securities of PSUs, securities that are part of an index, shares that have paid dividends in previous 3 years. Stocks that went through IPO within the last 1 year, those that are traded in the derivatives segment, securities with significant institutional holding, or those that are currently undergoing merger or demerger under a scheme of arrangement. Companies with market cap below 25 rupees crores but trading at PE ratio that is greater than 2 times the PE of benchmark index, or is trading at negative PE ratio with price to book ratio that is negative or 2 times the price to book of the benchmark index. Additional Surveillance Measures ASM. While GSM identifies securities based on their valuation, ASM identifies and shortlists securities based on variations in the price and volumes of securities. It also takes into consideration the percentage of volume traded by the top 25 clients in certain cases. The various factors that ASM takes into consideration include the following. Variation between the high and low prices in the previous 3 months. Variation between the closing prices over various time frames, including 1 month, 60 days, and 365 days. Client concentration, that is, percentage of volume traded by top 25 clients in each stock. Variation in the volumes traded over different time frames. The criteria vary partly based on the market capitalization and PE ratio of the stocks. ASM is, however, not applicable for the following securities. Securities that are already under GSM. Securities that are placed under trade for trade segment. Securities on which derivative products are available. Public sector units. Once a stock has been shortlisted under ASM, the applicable margin on security is raised to 80%. The restrictions are further tightened as the security meets additional criteria. Such restriction includes narrowing of the price bands and increasing margin to 100%. Stocks that are listed under ASM are reviewed after a minimum time period, and they are removed from ASM if they stop meeting the shortlisting criteria on such review date. As per the SEBI directives, the research analyst/investment advisor (RAs/IAs) are required to ensure compliance with the following advertisement code. A. Forms of communication. 1. Advertisement shall include all forms of communications issued by or on behalf of IA/RA that may influence investment decisions of any investor or prospective investor. 2. The forms of communications to which the advertisement code shall be applicable shall include pamphlets, circulars, brochures, notices, research reports, or any other literature, document, information, or material published or designed for use in any publication or displays such as newspaper, magazine, signboards/hoardings at any location in any electronic, wired, or wireless communication such as electronic mail, text messaging, messaging platforms, social media platforms, radio, telephone, or in any other form over the internet or over any other audiovisual form of communication such as television, tape recording, videotape recordings, motion pictures, or in any other manner whatsoever. Further, a research report, irrespective of the mode of its dissemination to any investor or prospective investor, shall be construed as an advertisement if anything contained in the said research report is either expressly or impliedly in the nature of promotion of products or services offered by an RA. B. Information/disclosures in the advertisement. The information/disclosures that the advertisement shall contain include the following. 1. Name of the IA/RA as registered with SEBI, registered office address, SEBI registration number, logo/brand name/trade name of IA/RA, and CIN of the IA/RA if applicable. 2. Information which is accurate, true, and complete in unambiguous and concise language. 3. Standard warning in legible fonts, minimum 10 font size, which states investment in securities market are subject to market risks. Read all the related documents carefully before investing. No addition or deletion of words shall be made to or from the standard warning. 4. In audiovisual media-based advertisements, the standard warning in visual media-based advertisements and accompanying voiceover reiteration shall be audible in a clear and understandable manner. For example, in standard warning, both the visual and the voiceover reiteration containing 20 words running for at least 10 seconds may be considered as clear and understandable. 5. Whenever the advertisement is being issued in a language other than English, it will be ensured that the standard warning is accurately translated in the language of the advertisement. 6. In case the mode of advertisement is SMS/message/pop-up, social media, etc., and the details such as full name, logo/brand name, full registered office address, SEBI registration number, membership number of a SEBI-recognized supervisory body, and standard disclaimer are not mentioned, then official website hyperlink should be provided in such SMS/message/pop-up, etc., and the website must contain all such details. 7. In case any specific securities are displayed in the advertisement as examples, disclaimer that the securities quoted are for illustration only and are not recommendatory should be mentioned. 8. Advertisements and communications/correspondences with clients shall include the disclaimer that registration granted by SEBI, membership of BASL in case of IAs, and certification from NISM in no way guarantee performance of the intermediary or provide any assurance of returns to investors. C. Prohibitions in the advertisement. The advertisement shall not contain 1. Anything which is prohibited for publication under the law. 2. Statements which are false, misleading, biased, or deceptive based on assumptions or projections. 3. Any misleading or deceptive testimonials. 4. Statements which, directly or by implication or by omission, may mislead the investor. 5. Any statement likely to be misunderstood or likely to disguise the significance of the same or any other statement contained in the advertisement. 6. Any statement designed to exploit the lack of experience or knowledge of the investors. 7. Any statement that is exaggerated or is inconsistent with or unrelated to the nature and risk and return profile of the product. 8. Extensive use of technical or legal terminology or complex language and the inclusion of excessive details which may distract the investors. 9. Reference to any report, analysis, or service is free unless it actually is free and without condition or obligation. 10. Any promise or guarantee of assured or risk-free return to the investors. 11. The advertisement shall not imply any assured returns or minimum returns or target return or percentage accuracy or service provision till achievement of target returns or any other nomenclature that gives the impression to the client that the investment advice/recommendation of such report is risk-free and or not susceptible to market risks and or that it can generate returns with any level of assurance. 12. Any statement which directly or indirectly discredits other advertisements or intermediaries or makes unfair comparisons or ascribes any qualitative advantage over other intermediaries directly or indirectly. 13. Reference to past performance of the IA/RA. 14. Superlative terms such as best, number one, top advisor/research analyst, leading, one of the best amongst market leaders, etc., so as to provide any endorsement of quality or standing of the IA/RA. However, factual details of awards received by the IA/RA from independent organizations may be included. 15. Advertisements shall not include SEBI logo. D. Other compliances/requirements. 1. Prior approval for the advertisement/material shall be obtained from SEBI-recognized supervisory body, example, BSE Administration and Supervision Limited, BASL, in case of IAs, before issue. 2. In the event of suspension of any IA/RA by SEBI and or by SEBI-recognized supervisory body, the IA/RA so suspended shall not issue any advertisement either singly or jointly with any other IA/RA during the period of suspension. 3. The IA/RA shall not engage in games, leagues, schemes, competitions, etc. which may involve distribution of prize monies, medals, gifts, etc. 4. These norms shall be applicable to any other investment/research/consultancy agency associated with the IA/RA concerned and issuing advertisement wherein the IA/RA has been named in the advertisement. 5. Copy of the advertisement shall be retained by IA/RA for a period of 5 years in terms of Regulation 19(2) of the SEBI Investment Advisors Regulations 2013 and Regulation 25(2) of SEBI Research Analysts Regulations 2014 respectively. 6. Any additional guidelines as may be specified by SEBI or SEBI-recognized supervisory body from time to time. Pertaining to the usage of brand name and logo by RAs/IAs, the SEBI guidelines direct the following. 1. While investment advisors and research analysts may use the brand name/trade name/logo in order to ensure the transparency in such a usage of brand name/trade name/logo, they shall ensure that 1. The information such as name of the IA/RA as registered with SEBI, its logo, its registration number, and its complete address with telephone numbers shall be prominently displayed on portal/website, if any, notice board, display boards, advertisements, publications, know your client forms, and client agreements. 2. The information such as name of the IA/RA as registered with SEBI, its logo, its registration number, its complete address with telephone numbers, the name of the compliance officer, his telephone number and email address, the name, telephone number and email address of the grievance officer or the grievance redressal cell shall be displayed prominently in statements or reports or any other form of correspondence with the client. 3. Disclaimer that registration granted by SEBI, membership of BASL in case of IAs, and certification from NISM in no way guarantee performance of the intermediary or provide any assurance of returns to investors. Shall be mentioned on portal/website, if any, notice board, display boards, advertisements, publications, know your client forms, client agreements, statements or reports or any other form of correspondence with the client. 4. SEBI logo shall not be used by IA/RA. SEBI Investor Charter and Complaint Disclosure. 1. In order to facilitate investor awareness about various activities which an investor deals with while availing the services provided by research analysts, SEBI has developed an investor charter for research analysts. This investor charter for research analysts is a document containing details of services provided to investors, their rights, do's and don'ts, responsibilities, investor grievance handling mechanism, and estimated timelines thereof, etc. At one single place in a lucid language for ease of reference. The investor charter is provided at Annexure 1. 2. All registered research analysts are required to bring to the notice of their clients the investor charter by prominently displaying on their websites and mobile applications. Research analysts not having websites/mobile applications shall, as a one-time measure, send investor charter to the investors on their registered email address. Additionally, in order to enhance transparency in grievance redressal, research analyst RA shall disclose on their websites/mobile applications all complaints, including scores complaints received by them in the format mentioned in Annexure 2 on a monthly basis. The information shall be made available by 7th of the succeeding month. Research analysts not having websites/mobile applications shall send status of investor complaints to the investors on their registered email on a monthly basis. Further, research analysts are advised to display link/option to lodge complaint with them directly on their websites and mobile apps. Additionally, link to Scores website/link to download mobile app SEBI Scores may also be provided.